The overarching principle of admissibility of the evidence is the relevance of the evidence to the facts and issue of the case. For the evidence to be admissible, it must be relevant to the case in hand and to the facts that need to be proved. But the relevance could be direct relevance or indirect relevance. To be admissible evidence looked at alone or with the other evidence, it must be directly or indirectly relevant to the facts in issue, in the sense of making that fact more likely. So, if you're saying something that something is correct, someone has done a murder, you have to give evidence against that person, and that evidence will make your case, make that fact that what you are saying that that person has committed a murder more likely. The court shall have the ground to believe that that person has committed the murder, and that's how that evidence is relevant and has a due weightage in the court of law. Relevant evidence is evidence which makes the matter which requires proof more or less probable. So the relevant evidence is something that could give due weightage to the case in hand or could thrash that weightage. So if someone is saying that someone has committed a murder and you don't believe it, you have seen that person not committing the murder but someone else doing the murder, you give the evidence in favor of the defense, then it makes less probable that of the the fact of the case against the defense is less probable to be true. So there is direct and indirect evidence of the fact in issue. If the evidence is direct evidence of the fact in issue, there can be no argument about its relevance. So if evidence is direct evidence, there is no argument about the relevance. A witness to the robbery gives evidence of seeing D strike V. A witness to robbery gives evidence of seeing D strike V and take his watch. So it is direct evidence as the witness has seen the person who has committed the theft. A rape commit gives evidence that she did not consent to the intercourse. That is also direct evidence because that thing happened to her. So she has seen it directly because it was happening to her directly. If the evidence is indirectly relevant to the fact in issue, then the party calling the evidence must always be prepared to argue why it is relevant. So if it is indirectly relevant because of something, the party which is giving the evidence must also prove that why is it relevant. For example, how it makes a fact in issue more likely. But why is indirect evidence given due weightage in the court of law? This is because of the fact that many cases rest wholly and substantially on circumstantial evidence or indirect evidence. In many murder cases, for example, the only person who could have given direct evidence of the crime is dead. So the person who has a direct evidence, if he is dead, so how shall you prove the evidence without giving the indirect evidence? How shall you prove the case without giving the indirect evidence? So that's why indirect evidence is also given the due weightage in the court of law. A large proportion of the legal arguments in the criminal cases are concerned with the relevance of the evidence.